If you're a trustee planning to sell a home held in a trust in Sonoma County, one of the first questions you'll face is, do you need a judge's permission or court approval to sell? The short answer is usually no. But the details matter, and getting them wrong can delay your sale or create real liability for you. The rules governing trust sales in California apply countywide, and Sonoma County sees a significant number of these transactions every year. If you're a trustee, a beneficiary, or a family member trying to understand your options, this video is for you. Under California's probate code, a successor trustee generally has independent authority to sell real property without court approval. That power comes directly from the trust document itself. When the trust was originally created, the original trustee or grantor, the person who set it up, typically gave the successor trustee broad powers to manage, sell, and transfer assets. As long as those powers are spelled out in the trust document, the trustee can move forward with the sale the same way any property owner would. This is one of the biggest advantages of a properly drafted trust. No waiting on a court calendar, no judge signing off, no public notice requirements. The trustee can list the property, accept an offer, and close, and often on a timeline that aligns with the market. Before we go any further, if you're a trustee or a family member dealing with an inherited home in Sonoma County right now, I specialize specifically in trust and probate sales throughout Sonoma County. I'm happy to answer your questions, walk you through the process, and help you understand your options at no obligation, no pressure. My contact information is in the description below. Reach out to me anytime. Now, there are situations where court involvement is required or strongly advisable. The first is going to be the trust document itself requiring it. Some older or conservatively drafted trusts include language mandating court approval for real estate transactions. Always review the trust fully before listing anything for sale. The second is if there's a dispute among beneficiaries. If beneficiaries are contesting the sale, the trustee's authority, or the terms of the trust, a court may need to intervene. In Sonoma County, those matters go through the probate division of the Superior Court right here in Santa Rosa. The third is if the trustee has a conflict of interest. If the trustee is also the buyer or stands to personally benefit from the sale in any unusual matter. Third is if the trustee has a conflict of interest. If the trustee is also the buyer or stands to personally benefit from the sale in an unusual way, court oversight protects everyone involved. Now, here's what needs to be in place before you list the house for sale. First is going to be a copy of the trust document itself or a certification of trust confirming the trust's authority to sell. This is what escrow and title will require to ensure the transaction. Confirmation that all named successor trustees are aware of and aligned on the sale, and verification that the property is actually titled in the name of the trust. Escrow and title companies will require these documents, so getting them together early is one of the simplest ways to keep a trust sale on track. Trust sales in Sonoma County can move quickly when everything is properly in order. The key is knowing what to look for before you list and working with someone who does this regularly. I am a Sonoma County Realtor who specializes exclusively in inherited home sales, including trust and probate properties throughout the county. If you're a trustee or a beneficiary or a family navigating this problem, I'd welcome the conversation. My number and email are in the description below, and subscribe for more videos built specifically around inherited real estate in Sonoma County. And I will see you in the next one.